Good afternoon. My name is Stephen Shoemaker of the Wishart Law Firm. I'm an associate lawyer here. And to my left is Tim Harmer, also an associate lawyer with the Wishart Law Firm. And we're back today with a further presentation in our municipal law webinar series in respect of the Line Fences Act. Tim, I think we should probably start with when does the Line Fences Act apply? And if the viewers, you can keep track of our slides here online.
Yeah, I'm going to hit start broadcast.
So start over. Start broadcast. They didn't hear anything I said. Flip back to the main screen. Good afternoon. My name is Stephen Shoemaker. I'm an associate lawyer with the Wishart Law Firm. And to my left here is a co-worker and associate lawyer with the Wishart Law Firm as well, Tim Harmer. And we're here today to another edition of our municipal law webinar series. Today's presentation is in respect of the Line Fences Act. I think where we'll begin is with the when the Line Fences Act applies, and for that I'll allow Tim to start us off.
Well, yeah, thanks very much, Steve. And actually, Steve's going to be controlling the presentation, so you'll probably hear me ask Steve to go to the next slide from time to time. So I wanted to just run through the outline of today's presentation with everyone. But before I do, I actually want to mention again, for those of you who attended our last presentation, our last webinar, if you have questions, I believe that they can be submitted electronically, and we'll try and get to as many of those as we can, either as as we go through the presentation or at the end if there's time for question and answer. And if we don't get to your question, you'll be given our contact information at the end of the presentation, and feel free to contact us, and we'll help you out if we can. And actually, last thing before we get going, I just want to mention that we really value your feedback. You'll be being sent a survey after today's webinar, and I sincerely hope you'll be able to fill it out. We really appreciate any thoughts you have as well on other webinar topics. This actually Line Fences Act webinar was actually the idea of one of our previous attendees, and so we're happy to be able to do this today. And thank you all for joining. So, as Steve said, what we're going to do first is it makes sense to talk about when the Line Fences Act applies. Then we're going to get into what council's role is with respect to the Line Fences Act, and then who should be appointed as fence viewers. We'll talk about the municipality's discretion in that respect. We'll also talk about when fence viewers have jurisdiction, and probably one of the more important topics we have is what responsibilities does the clerk have with respect to the Line Fences Act. And as I mentioned, we'll close with question and answers to the extent time permits. Steve, next slide. Thanks very much. So under Section 23 of the Line Fences Act, it applies to lands owned by a municipality, local board, or conservation authority. And if there's an unorganized municipality, Ministry of Municipal Affairs has jurisdiction and should be contacted. So it also, even within lands to which the Act applies, it does not apply to land that constitutes a public highway, and that includes lands abutting a public highway held as a reserve by the municipality, and that's under Section 25, subsection 1. Really, the meat of the application of the Act, though, is that it applies to line disputes between adjoining property owners. Now, a line fence is a fence that runs along the boundary between two properties, and so one of the roles that the clerk has at the outset is determining, is this dispute really about the fence, the actual fence itself that runs along that boundary, or is it an attempt to use the Line Fences Act to arbitrate a dispute that's really about the location of the boundary line? In which case, if it's properly about the boundary line, then the clerk should reject the application, and we'll talk about this some more as we go through. enforcement. But that's an initial question that should be determined. Now, there are two situations where the Line Fences Act applies, and so it applies where there's a line fence that currently exists at the boundary between two properties, and where one owner wants to construct a new fence, or I should say, wants to construct he or she a new fence where no fence exists on that boundary, or where there is a fence that already exists, where one of those two adjoining owners believes that it's in need of repair, and there's a dispute as to the apportionment of costs in respect of that repair.
And two items I would just like to add to that, Tim. Thank you for that overview as to the application of the Act. I think it's important to note and to build upon one item that you mentioned where the fence is constructed in a way that in the past it has taken a piece of the adjoining landowner's property, for example, and perhaps there's an adverse possession type claim. The Line Fences Act will not provide any relief or any answers in respect of determining that adverse possession issue or the issue of the boundary between the two properties in that example. Also, another situation where I know we've got a number of clerks here today joining us, where the clerks often have trouble determining the application of the Act, especially in one circumstance where the fence is either constructed already, and then the owner of the payor for the fence construction comes to the municipality seeking relief under the Line Fences Act. The Line Fences Act would not apply in that circumstance. But where the fence has been commenced as well, and then the owner comes, the clerk sometimes has some trouble determining whether the Line Fences Act does apply. And typically the clerks will say if any construction has commenced or reconstruction or repair, that the Act does not apply, because the intent is to bring these problems to the clerk and to the municipality in advance of steps being taken, overt steps being taken by one of the owners, which could and will likely cause issue for the clerk and for the fence viewers. And so we'll get to the fence viewers, the term the fence viewers here now. If you'd like to add on to that, Dan.
Sure. Well, actually, that Steve brings up a really good point about the fence that where the situation, which sometimes does happen, where one owner just goes out and decides to build a new fence using perhaps very expensive materials, let's say, and there's a disagreement with the adjoining owner about the expense that's been involved, and the owner that's sort of unilaterally constructed this fence tries to use the Line Fences Act as sort of an after-the-fact mechanism to recover their costs, and that's a situation to which the Line Fences Act does not apply. It does not apply where an owner has already built a fence and is trying after the fact to have their neighbor pay for the cost of that construction or part thereof. So, council's role in administering the Line Fences Act is somewhat unique. It's council has the power to and is required under Section 2 of the Act to appoint the fence viewers. We'll talk about who can be appointed as fence viewers in another slide, but council also has to set the remuneration of fence viewers, the payment that they're entitled to. They are entitled to be paid for their time. Again, Section 2 speaks to that. Council can also prohibit, it's not a requirement, but council can prohibit a proceeding during the winter months. So can prohibit a proceeding at which the viewers would have to attend off-site during certain months of the year. The idea there being if there's snow or ice conditions, the municipality can actually prevent or prohibit the proceeding from occurring in such circumstances. That doesn't apply, however, to an appeal of the decision of the fence viewers to a referee. We're not going to get to that level of detail today, but of course, if you have specific questions, we're happy to help out. Again, establishing administrative fees. Council has the authority to do that. Council can also delegate we use the term clerk throughout the presentation, but actually, council can designate the clerk's responsibility to another individual. And so, where that delegation has taken place under subsection 4, sub 2 of the Act, we would sort of just simply replace the term clerk with whoever that delegate may be. And also, very importantly, the council can pass a bylaw that exempts all or part of the municipality from the Act. And so where a bylaw is in place exempting a certain part of the municipality, then that bylaw governs the disputes between adjoining property owners with respect to fences in those areas. The caveat there is that Section 20 of the Line Fences Act will still apply. Section 20 is basically says that it covers railway lines where there's been an agricultural use of railway fences, I should say. So that's probably not a circumstance that will occur that often, but we raise that just as necessary background.
And I think building on that slide, Tim, I think it's important to note that while council does have this authority pursuant to the Act, typically once council appoints its fence viewers, and these individuals exist as fence viewers, the council's role is really to take a step back from the process. The fence viewers are carrying out a quasi-judicial type role in that when an owner or two owners go to the clerk and say, we'd like this fence issue to be resolved pursuant to the Line Fences Act, the clerk then will appoint an attendance according to the rules set out in the Line Fences Act, so that 3 fence viewers can go to the property to determine the issues in respect to the installation, repair, or reconstruction of this fence. So council is not to instruct the fence viewers in any way, and council, which would be appropriate in council's role, is really after its obligations under Section 2 are satisfied. Council's role is to take a full step back, and council's not involved in any decision making by the fence viewers, not involved in any of the appeal process of the fence viewers' decisions either. And I think it's also important to note, as you've indicated, Tim, that a municipality may pass a bylaw. So either the bylaw, it's a black and white sort of situation. Either the bylaw will apply to the fence viewers' decision making in the first instance, or where the bylaw does not exempt provisions of the Line Fences Act, then the Line Fences Act would apply. And sometimes aspects of the Line Fences Act will apply in certain sections, and where the bylaw hasn't overridden those aspects and provisions, then the bylaw would also apply in the other circumstances. So it's one or the other in respect of each of the provisions, but sometimes if it's not a full overriding of the Act, ignoring Section 20 for a moment, then the fence viewers would have to consider both the Act and the bylaw. But they are mutually exclusive in those considerations. And as well, I think it's important to note, Tim has mentioned that the Act doesn't apply to railway, agriculture, and livestock type situations where fencing is to be determined in those specific situations. There are other acts that apply, and if you have any questions regarding those other acts, like the Pounds Act, there's some provisions under the Municipal Act, or provisions related to railways, which are very specific to railway situations, then we would be happy to help answer those questions when they do come up. Yeah, we will go to the next slide.
Okay, so the Act, as Steve said, the Act requires there be 3 fence viewers present at a viewing. And we recommend, though, that council can appoint as many fence viewers as council wants. And we think that appointing more than 3 fence viewers is a good idea, and the reason for that being is it's a good idea to have a substitute fence viewer just in case there's a conflict of interest. Let's say if one of the fence viewers just happens to be, let's say the second cousin of one of the property owners. In those circumstances, it would be handy to have a substitute fence viewer who could relieve that viewer and be assigned to that viewing. So that's something to consider, I think. Also, it's a best practice. When do you appoint fence viewers? That's really what the next bullet is about. And you can there's sort of two ways of looking at this. Some municipalities may have not had an application of the Line Fences Act for a long time, and because of the infrequency of those applications, they may choose to appoint fence viewers once an application is received. Another approach is to appoint fence viewers at the beginning of every year, for example. One of the reasons that the latter can be a good idea is because the Act requires that a viewing take place within 30 days from the date the application, or as we see the application being Form 1, is received or submitted, let's say, to the clerk or clerk's designate. And so if the difficulty arises if you have to conduct a viewing within this 30-day period and you don't have fence viewers appointed already, there can be a real time crunch, and you wouldn't want to be scrambling, hopefully, in that circumstance to get fence viewers appointed.
Both appointed, and you'd have to proceed according to their schedules existing at that point, whereas if they're on notice in advance, certainly there's an expectation on their part that they may have to ultimately adjust their schedules for fence viewing to take place. And I think it is important to note that while there is the obligation to remunerate these individuals, they can be paid an hourly or a daily rate or rate for each time that they're called upon. So really there is no necessary downside to appointing these individuals for an extended period of time when council makes most of its appointments in the first meeting after the next council is ultimately elected. So typically an early December meeting every 4 years, which would be probably best practice and avoid a number of issues for municipalities and councils moving forward with these applications.
And the nice thing is the final bullet point there just was saying that really there's no sort of specific requirements on who can be appointed as a fence viewer. There's no restriction. So council has a fair amount of leeway and discretion there. I mean, often you see in more rural places it may be people with an agricultural background just because of the experience that they may have with fences, and similarly in more urban environments, you might see contractors, former contractors, ex-building inspectors, things like that. But there's certainly no set criteria that a person has to have a certain experience with fences to be eligible as a fence viewer.
Great. Thank you, Tim. The next slide we've essentially already covered, which involve the situations where the clerk may ultimately accept or reject a application, and the alternative forums for owners who are attempting to resolve issues of fencing and boundary disputes, which don't necessarily fall under the Line Fences Act, would be through the civil court system. The slide here, when do fence viewers have jurisdiction, is also information that we've covered. For example, like we said before, this isn't a boundary dispute resolution process. It's a fence repair, reconstruction, and installation act and application. Again, if they've started the construction, that is likely going to result in the application being rejected by the clerk. What responsibilities does the clerk have, which is important, of course, to I believe many of our attendees today. The clerk must ensure that the owners attempt to not ensure, but the clerk's efforts in the first instance should be to attempt to mediate and have the resolution of the issues discovered and determined informally. Of course, if an application is going to be made, then pursuant to the regulations of the Act, certain forms are required, and Form 1 is mandatory to be filled out by the applicant. Tim, I'll let you take this section here, just because I know that you're quite familiar with it.
Yeah, you know, this is the kind of the next bullet is really just about the kind of information that you may want to provide. It's not mandatory, and these are really just examples of the types of information that prior to a viewing the clerk may want to provide, or to designate, I should say, provide to a fence viewer. Things such as, and the fence viewing bylaws enforced in the municipality. The reason being is any award that the fence viewers might provide would have to accord with those bylaws, and that's under Section 8 Sub 3 of the Act. And so basically, you couldn't, you know, if there's certain height requirements, etc. In a bylaw, the award certainly would have to conform with those. There's a notice, the notice that was sent to the owners, Form 2, together with proof of service. The reason there is simply in case one of the owners attempts to say that they were not given proper notice that the fence viewers were going to attend their property, and the proof of service should be sufficient to overcome that argument. Just in case somebody, fence viewers do have the ability to take evidence from the owners and or other witnesses, and so a copy of the language to administer oaths would be beneficial potentially, and also a copy of the, and this may be perhaps going a bit far, but to be very cautious, you could provide a copy of the Statutory Powers Procedure Act to the fence viewers, because that act sets out some of the procedural rules applicable to the viewings. So it may be a good idea, or perhaps just exempting key sections from that act and providing those.
I think the important point to note there is, especially when we're giving advice to clerks of municipalities and townships, our advice is to err further on the side of caution and to provide as much of that documentary material that you can, so that ultimately, if there's a complaint, the clerk can say that they've taken the necessary steps pursuant to their obligations under the Line Fences Act and other acts which may be relevant. And further, that the process from that point on, from the clerk requiring that the fence viewers attend under the application, that process is appropriate, and ultimately the owners, based upon the decision of the fence viewers, at that point, don't have any complaint with the process leading up to the decision of the fence viewers, and can then pursue an appeal if necessary. The Line Fences Act does permit appeals of the fence viewers' decisions, and those appeals are provided for directly within the Line Fences Act to an individual known as a referee within the Act, and is a provincially appointed individual to consider an appeal. And it is generally, if not exclusively, an appeal in writing where the fence viewer's decision is reconsidered to some degree, and that's provided for in the Act. I will go to the next slide here. Some of the, as we've covered, of course, the clerk's obligations beyond documentary disclosure of relevant information are to, of course, schedule the viewing, arrange for the viewing of the fence viewers, and typically you're going to want to ensure that as a clerk, the fence viewers are attending when both the homeowners can be present. There's formal notices of the viewings as provided for in Section 4 of the Act, and the clerk's obligations are to also ensure that, depending on what council has set out as the remuneration package, that the fence viewers are paid, and that the necessary steps and provisions are followed to ensure that they're paid. like to add on to some of that too.
Yeah, I think Steve summarized it quite well. There's certain notices that do, of course, need to go out, and those are in prescribed forms under the regulations. Form 2 is the form used to go to the two adjoining owners to the dispute, and also Form 3 to the fence viewers. That's for the notice of the viewing. And it's important to note that those notices do have to be served at least 1 week prior to the date of the viewing. So, and Steve also touched on the remuneration to the viewers. These bullet points basically provide some guidance on when the fees payable to the fence viewers are due, and basically fees are to be paid after the appeal period before the award expires. And if there are circumstances where the fence viewers may not make an award, in which case the fees are due when they submit their either a certificate of default, a determination with direction, or a decision. They may make a decision not to make an award under Section 14. So it's in those circumstances, it's due at the date of that, let's say, a decision or the submission of the certificate of default, etc. Yeah.
And I think, Tim, I see that there's some questions that have appeared here. One of them being quite interesting in respect of question posed, so does Section 26 of the Act can be passed to exempt the entire municipality from the Act? That is true to some degree. I wouldn't want to convey the message that municipalities can exempt themselves from the Act and then simply wash their hands of fencing type disputes where it involves installation, repair, or reconstruction. The council and the municipality cannot say that it has no fence viewers and no way for a fencing dispute to be arbitrated. It can exempt itself from certain provisions wherein the bylaw replaces those provisions perhaps with a predetermined 50-50 percentage in certain circumstances regardless of the type of fence or the extent of the responsibility under the Line Fences Act, but it cannot wash its hands entirely of line fencing type disputes. It needs to have some bylaw language in place that properly covers off the provisions of the Line Fences Act that it's looking to exempt itself from.
It basically, but just my thought being is that you can, so the municipality can exempt itself if the entire land covered by the municipality from the application of the Act, of course, with the exception of Section 20, which we've talked about. But Steve's entirely correct in the sense that the municipality should, if it's going to exempt itself, it should properly have a bylaw that governs the disputes between adjoining landowners with respect to fencing. That's a very practical and very key issue, because the reality is these kinds of disputes are going to arise, and ratepayers are going to expect that if the Act is not going to apply, that the municipality is going to have some other process established by bylaw whereby disputes can be resolved.
And a further question is, do we have any sample bylaws? Yes, we do certainly have sample bylaws in respect of townships and municipalities relating to various degrees of municipalities being able to exempt themselves from the Act. And we could certainly provide some information and advice in respect to those sample bylaws if a township is looking to amend or revise their own bylaw, or is potentially looking to implement their first bylaw, which would ultimately cover off certain provisions of the Line Fences Act. For our last slide, I will flip here to the next slide, which is our contact information. And as we had indicated, your attendance is very appreciated, and we are more than happy to consider any and all questions you may have. Not that this is the end of the presentation, but I will allow Tim to finalize any thoughts that you may have as well.
I'm coming back just momentarily to that question about the ability of the municipality to exclude the application of the act, and it's something that I would like to actually consider with Steve and possibly send out an email response to the attendees. And the reason being is that I'm questioning whether the municipality could, if it truly desired to divorce itself from all but, of course, Section 20 of the Line Fences Act, if it could, by bylaw, exclude the act in its entirety, and the resort that the owners would have to resolve their disputes in those circumstances would simply be to the civil courts. Now, I don't know. I think from a practical perspective, there should be a fence bylaw in place if the act is to be excluded. That being said, could it be, and could the municipality shift the adjudication process for disputes to the civil court system?
It's a good question.
I'd like to go that in a bit more detail. It's a very good question.
Good, and we've got some other follow-up questions in that respect as well. So we will send out a response in that regard if and when, or if there's a reasonable situation where you would exempt the act in its entirety, and whether there'd be some benefits to residents for a municipality doing so, and what ultimately may be the arbitrated or the dispute resolution process thereby remaining after the act was entirely excluded.
I think practically speaking, there's some great benefits to having the act or a bylaw deal with these disputes from a ratepayer's perspective, in the sense that the civil courts are often very intimidating and can be, depending on the level of the dispute, if it goes beyond the small claims court matter, can be quite expensive. And so having a very, what the act does, provide a very expedited and very inexpensive comparatively to the courts process to get these disputes resolved. And another benefit of having a bylaw or having the Line Fences Act apply is very simply that it might help the relationship between the adjoining property owners, because often when people get to court, by the time they get there, emotions have run high, and the dispute may have blown well out of proportion versus what would have otherwise what it would otherwise have been had it been expeditedly dealt with under the Line Fences Act or comparable municipal bylaw. So there's some concrete benefits to ratepayers to having, either having a bylaw if they're going to exempt, if the municipality is going to exempt itself from the Line Fences Act, to having a bylaw in place that governs an expedited resolution of those disputes before they escalate any more than is necessary.
Good. Well, I thought that was very informative as I was researching and investigating the issues, and we've got some questions to keep us busy and in responding to our viewers and attendees. I see some further questions that have come up here that we will certainly get to, and we will reply directly to the individuals who asked those questions. Again, thank you very much for attending. We're going to be holding further municipal webinar seminars, and we will send out notices and invites when we have our next subject matters. Again, if you've got any subject matters that you'd like to see us present, please contact us at the above emails, and we really look forward to the next subject matter.
Yeah, thanks very much, everyone, and you'll be getting a survey as well. We look forward to your feedback, and as I say, we'll certainly investigate that the question of the exclusion of the act more thoroughly, and send out a reply email shortly. So just thanks again, everyone, and we'll see you at the next webinar.
Have a good afternoon. Bye.